Is Mr. Fortin there? Oh, there he is. I hadn't seen Monsieur Fortin. Wonderful.
To order, welcome to meeting number 97 of the House of Commons Standing Committee on Justice and Human Rights. Pursuant to the order adopted by the House on February 7, 2023, committee's meeting in public to begin its study or to continue its study of Bill C-332, an act to amend the criminal code controlling or coercive conduct. Today's meeting is taking place in a hybrid format. Members are attending in person in the room and remotely using the Zoom application. We have two witnesses in the first panel. Both are attending via video conference. Both witnesses have been tested for sound. Please wait until I recognize you by name before speaking. For the benefit of the witnesses, you'll be allowed a specific time frame for your opening remarks, as well as answering questions for each of the members. I will have to be a bit strict on the time usage, so please bear with me. I ask for your patience. There's a rotation that we follow. All comments are to be addressed through the chairs. And for members using the Zoom, you can either raise your hand using the Zoom function, and for those in the room, obviously you know how to seek my attention. So I just want to welcome our witnesses for the first 45 minutes. We have them both with us by video conference. We have Barbara Schliefer, Commemorative Clinic, Deepa Mattu, Executive Director, and from the Women's Legal Education and Action Fund, Roxana Parsa, staff lawyer. You each have 5 minutes for your opening remarks, and I will start with Madame Mattu.
Good morning, Honorable Chair and members of the committee. I'm grateful for this opportunity to speak before you this morning regarding the proposed legislative amendments aimed at addressing coercive control within the criminal code. The Barbara Schliefer Commemorative Clinic since 1985 has been at the forefront of providing trauma-informed legal, counseling, and interpretation services. We support marginalized and racialized women and gender-diverse individuals who have experienced violence. With their extensive experience and expertise in this field, we offer insights into the potential implications of the proposed legislative change. I'll cover 3 points in my opening remarks. Justice should not only appear to be served, but it should genuinely be achieved, consequences of criminalization, and the need for a holistic approach to address coercive control. I want to start by recognizing and commending the intent behind this legislative change. It signifies a crucial milestone in acknowledging and addressing coercive control as a pervasive form of intimate partner violence. However, you must approach this legislative change with utmost caution, taking into account the intricate nuances and potential ramifications of criminalizing coercive control within the criminal code. Coercive control is characterized by a relentless pattern of behavior aimed at intimidating, manipulating, and inflicting harm upon survivors or the victims. This insidious form of abuse often operates behind closed doors, making it challenging to identify and prosecute. Survivors may endure multiple forms of tactics, including manipulation, financial control, and isolation, which can result in profound psychological and emotional trauma. My first point is that justice should not appear to be served. While the criminalization of the coercive control may seem like a solution, it's crucial to recognize its practical limitations and potential consequences. Coercive control, particularly within intimate partnerships, possesses inherent complexities, making it difficult to recognize and report due to inherent power imbalance and the systemic biases that survivors face. Moreover, proving coercive control beyond a reasonable doubt in a court setting would add a layer of difficulty that survivors routinely face in IPV and sexual violence cases. In these cases, the system routinely fails survivors with underreported cases and low conviction rate. Therefore, my point being that justice should not only appear to be served with a new criminal offense on the books, but we should genuinely be trying to achieve this justice for survivors. The unintended consequences of criminalization don't always align with the intended solutions. For example, we have observed that existing mandatory charging policies in cases of domestic assault can inadvertently result in survivors being charged in the same offenses that were meant to protect them. Moreover, survivors, particularly those from marginalized and racialized communities, specifically from non-status immigrant communities, indigenous and LGBTQ plus communities face additional hurdles such as language barriers, discrimination within the system, and intergenerational trauma and lack of trust in the legal system. My last point is that it is essential to explore holistic approaches that prioritize survivor safety and well-being while holding perpetrators accountable within the criminal justice system. So drawing from the experiences in the jurisdictions where coercive control has already been criminalized, such as England, Wales, and Scotland, we must recognize the limitations of relying solely on the criminal justice system. It is only one part of the solution. Comprehensive support services, awareness campaigns, and professional training are essential for meaningful change and healing for survivors. Furthermore, the inclusion of a broad defense based on the coercive actor's best interests for the survivor raises serious ethical and practical concerns, risking further harm to survivors and perpetuating power imbalance within abusive relationships. In conclusion, I echo the sentiment of many others who have already testified in front of this committee that increasing criminalization is not the solution. An emphasis on the Nova Scotia's Mass Casualty Commission's recommendation, which advocates for a community-based approach over a carceral one, including a community advisory, is something that we also support. While we oppose the implementation of the new offense for coercive control, we stress the importance of equipping all legal actors with the necessary knowledge and skills to identify and address coercive control effectively. This includes developing risk assessment tools and training that consider intersecting identity factors for survivors that are disproportionately impacted by the gender-based violence. We believe that introducing such legislation prematurely without adequate education resources, accountability mechanism in place for legal actors.
Thank you very much. Thank you very much for your opening remarks, and you'll have a chance to continue with that during questions. I will now turn to Madame Parsa.
Good morning. My name is Roxana Parsa. I'm a staff lawyer at the Women's Legal Education and Action Fund, also known as LEAF. I'm grateful to appear today from what is now known as Toronto, which is on the traditional lands of the Mississaugas of the Credit, the Wendat, Anishinaabe, and the Haudenosaunee nations. LEAF is a national charitable organization that has worked for 39 years to advance the equality rights of women, girls, trans, and non-binary people through litigation, law reform, and public education. In recent years, LEAF's engagement with the criminal legal system has led to a deeper understanding of the ways in which harms can be perpetuated through the justice system. This is why we are grateful for the opportunity to be here today to share our views against Bill C-332. We know that coercive control is a pervasive form of violence. We have heard the stories from survivors and frontline workers about the insidious ways in which patterns of controlling behavior develop over time, and we understand the desire to respond. We agree that there is a need for greater recognition of this harm. However, we urge the government to resist reliance on the criminal law. We echo the calls of experts who have testified before you this past week in speaking against the implementation of this bill. There are significant systemic barriers that exist within the criminal legal system that will render this bill ineffective. First, coercive control is a highly nuanced and case-specific concept which captures a wide range of behaviors. The lack of physical evidence often means that recognizing the existence of this form of violence involves a deep understanding of the dynamics and context of an interpersonal relationship. Given the subtleties of coercive control, there's a significant risk that when granted judgment, law enforcement may misinterpret situations of abuse or see abuse even when it is not present. Abusers may also use this to their advantage and turn the law into a tool of coercive control, as we've seen with many other tools in the legal system. These risks are significantly heightened due to the existence of colonialism, institutional racism, and discrimination embedded within the justice system. There are decades of evidence which show how the criminal law harms survivors. We can look to the history of mandatory charging policies to see how the potential consequences of a new offense would emerge. These policies, while well-intentioned, led to a significant increase of arrests of female survivors, particularly amongst racialized populations. In Canada, this has been most strongly felt by Indigenous and Black women, who are at the same time groups that continue to face the highest rates of intimate partner violence. We fear the same consequences arising with the establishment of yet another criminal offense. We also know that despite facing higher rates of violence, the history of harm from the system results in a reticence to seek help. Many survivors will not contact the police when they are experiencing abuse, and when policing is seen as the primary solution to intimate partner violence, it inadvertently excludes survivors from marginalized communities and only deepens the existing inequities in seeking safety. In discussing the potential harms of criminalization, the conversation often claims that the benefits outweigh any potential risks. So we urge you to examine the question, outweighs the potential risks for whom? Who will be most impacted by a new criminal offense? The law does not exist in a vacuum, and when considering the development of a new offense, we need to center the experiences of survivors facing intersecting barriers to justice. Criminalization is likely to result in either a lack of protection or worse, cause further harm for survivors. And access to a legal mechanism is not necessarily access to justice. That is why, instead of focusing on the enactment of this bill, LEAF strongly recommends diverting resources to focus on prevention through the development of the infrastructure necessary for survivors to seek safety. This includes more funding for housing, social supports, and community services, and the development of alternative justice models for survivors seeking validation. We also echo the recommendation of earlier witnesses in advocating for mandatory and ongoing training to actors in the justice system on coercive control, as well as on systemic bias, alongside the development of accountability measures to ensure evaluation of whether training is meaningfully applied. Finally, we echo the Mass Casualty Commission's recommendations to strike an expert advisory group and consult with both experts and affected communities. Without systemic change, legislative reform only continues to hide the problem and gives the illusion of taking a stand. The criminal law has been turned to for decades as a response to intimate partner violence, yet the ongoing rates of violence show that it has been proven to be an ineffective response. We think it's time to look beyond the criminal system and focus our resources on developing the social systems that are necessary for violence prevention. Thank you for your time, and I'm happy to take any questions.
Well, thank you very much. Much appreciated. We will now start with our first round of 6 minutes each. Keep in mind, we need to conclude this panel in 30 minutes in order to have the second panel witnesses be tested as well. So I will start with Mr. Frank Caputo.
Thank you, Madam Chair. Thank you to our two witnesses for appearing with us. And Ms. Mathieu, I know you didn't get to finish your opening remarks, and I'm happy to yield my time to you to finish your remarks.
Thank you so much. I just had 2 lines left saying that we believe that introducing such legislation prematurely without adequate education, research, or accountability mechanism in place for legal actors risk further undermining access to justice for survivors. And thank you so much for giving me this time, because I just was going to offer to answer any questions.
Okay, well, thank you very much for that. I appreciate you both being here. Ms. Mathieu, my full disclosure, my wife runs 2 legal clinics where she serves primarily women and mostly marginalized women. And my background is as a Crown prosecutor, so I listened with intent to both of you as to what you had to say. And I found it interesting. Very much interesting, and I'm just trying to decide where to start because there's so much. But I know that Ms. Parsa, when she was speaking about this, spoke about that a law on coercive control, and just generally, if I took your comments correctly, was that the law should not be the primary mechanism by which we deal with intimate partner violence and coercive control, and that there should be a rededication or a redirection of resources. My question is this. In these situations, the law is reactive. You're speaking about something proactive. But should we not be reacting to the situations of coercive control that, I mean, statistically and in my experience, lead to and perpetuate what I would call and what others have called the cycle of violence? Just feel free to answer that.
So I can take the question, and Roxana, please add. I mean, if Canada recognizes coercive control as a criminal criminal code or a criminal, I know what I'm trying to say here, but I'm getting nervous. I don't know why. I usually never get nervous. Another section on the books. My challenge is like looking at thinking about what has England done and what has Wales done and what has Scotland done. And then Scotland's model is definitely seen as a golden standard. But the studies coming out of those jurisdictions have repeatedly told us that a number of people who were either convicted or charged with coercive control could have been charged under a number of a number of statute that was already available to the prosecutors in those jurisdictions. And that's the same case, I think, here in Canada. If you think about what is coercive and controlling behavior, criminal harassment, assault, sexual assault, forcible confinement, human trafficking, uttering threats, fraud, and stalking are all criminalized behaviors. So my challenge remains that while we have so many tools in the box, why do we want to add this one more thing, which is a contextual nature of the crime? And instead of giving proper education to our police officers and our prosecutors and our judges in understanding that context, adding this one more thing would unfortunately, in my opinion, add another layer of barriers in access to justice to the survivors, because now they have one more thing. And it might also give them this false notion that this is, coercive control is not criminalized. But in reality, the beyond reasonable doubt test would still remain the same. And they would still have to prove all of those actions or those situations that I just listed and more. So I really definitely find it really challenging to think about that, how it will resolve a problem which lies in lack of understanding of the context by the frontline responders and prosecutors and decision makers. So I do not believe that it will actually break the cycle of violence as suggested by you, honorable member. And in fact, that's also the evidence coming out of the countries and the jurisdictions where it has been criminalized.
If I could just respond to that, I take some of your points. I mean, for me personally, and again, this is just my anecdotal experience, coercive control takes the form of manipulation, and it is manipulation that is meant to control that isn't criminal harassment, whether it be repetitive, unwanted behavior, because the person might not even realize that they're under the thumb of their abuser. And often, in my experience, it takes the form of things that aren't illegal. Having a bank account, controlling all of the finances, isolation of a person that is so coordinated as to leave the person, the victim, vulnerable. That isn't covered under human trafficking. It's not covered under assault or criminal harassment. But the end goal is to ultimately leave the person more vulnerable. And I take your point about the nuances in the law and the difficulty of proof, and maybe that's incumbent on us to change some of the enumerated ways of identifying it. But in 20 seconds, what do you say to that?
I think I can agree with you on the point that none of the provisions that I listed have the repeated nature of the abusive acts as you are referring to. But again, my point is that it is the context of the violence that is not understood by the existing system. And unless and until we fix the existing system, we are actually putting the cart before the horse.
Thank you very much for that. I will move to Mr. Mendicino for 6 minutes.
Thank you, Madam Chair. Thank you to both of our witnesses for the very thoughtful interventions. And I'd like to start with a question to Ms. Parsa, if I might. And I take from your preliminary remarks that there are some underlying structural and systemic issues with the criminal justice system that need to be addressed before we consider adding yet another provision, which would be under the criminal code, to deal with coercive control. And to my recollection, you referred to looking at ways to devise alternative dispute resolution or alternative judicial resolution measures. Could you elaborate a little bit on what that looks like in your view?
Sure. So that's a big question, but that's something that LEAF has been engaged in a lot of research in this past year. What we're talking about is restorative justice and transformative justice models, and these can take a variety of different shapes, and they can exist within the legal system or outside the legal system. And so many of these take place in the community, and they involve a survivor who has access to the resources, but has been able to seek out a resource in which they feel safe and able to have some sort of resolution with their in their situation of violence. I think, to be honest, this is perhaps difficult to imagine in a situation where there is imminent harm, and it is. But I think this is the kind of resolution we are hoping to move towards for survivors who are seeking validation and recognition. Based on a lot of research that we've done, experiences of going through a restorative justice process, which can often mean um, it can mean something as simple as writing letters to the person who is the accused and sharing kind of thoughts through that. There can be a facilitator. It can be a long process involving therapists. Oftentimes, you don't even have to see the other person, like you don't have to come face to face. But these experiences often have been shown to provide survivors the validation that they don't get in the legal system. So they feel much more like their perspectives and their experiences have been recognized, and they have been, the person who harmed them has become accountable for their actions. And but there's a sense that they feel healed in a way that the justice system often does not provide. And so that's kind of what I'm speaking about. We've actually released a very lengthy report this past year, if you're interested, about specifically alternative and restorative justice models for sexual violence in particular.
I am interested, and if you'd be willing to provide it to the clerk, I think all members of this committee, and in fact all parliamentarians, would benefit from Leaf's study of restorative justice models like the one that you just described. And I agree that in some cases that restorative justice is a more appropriate, more validating model than going the full conventional criminal law route. And so I did want to validate that point of view. There may be cases, however, where restorative justice is not available. Would you agree with that?
Of course, I think our main point when speaking about restorative justice is really that we want the options. We think that survivors should have the options to pursue whatever form of justice they want, and that the criminal legal system shouldn't be kind of the only route forward.
And is it true that in a case where the victim or the survivor, and indeed all of the participants, do not voluntarily agree to participate in restorative justice, that may not be the most appropriate option?
Of course, there has to be consent on both sides to take part in these processes.
And so, I gather, turning back to this private members bill, which has been advanced by my colleague, Mr. Garrison, that's really the scenario in which the bill should be contemplated, perhaps where other alternative models may not be available for one reason or another. It may be because parties don't consent. It may be that there are some cases that are egregious, where serious violence has been involved. And as a result, we may have no other choice but to resort to the criminal law, despite the systemic challenges, which I think you've appropriately identified. In that scenario, what do you say? Is it that the existing laws that are on the books are sufficient or adequate to deal with coercive control, or do you acknowledge that perhaps by adding some additional language that defines coercive control, and I think Mr. Caputo provided some good examples for the committee and for you to contemplate, that it may make sense to look at adding additional provisions to deal with this type of harm towards disproportionately towards women?
I think I certainly understand that this desire to respond, especially when there's imminent harm or a situation of urgency, and survivors feel like they need help quickly. But I just go back to what my colleague, Ms. Mathieu, was saying, where I think the problem isn't that there aren't laws or there aren't these tools. The problem is that they're not used properly. And the existing laws that they are not being adequately used in these situations.
Thank you.
And
thank you very much for that response. Monsieur Fortin, alors c'est à vous maintenant.
Merci, Madame la Présidente.
Thank you, Madam Chair. Thank you, Ms. Mathieu. Ms. Parson is with us today. The issue of coercive and violent controlling behaviors is a part of our responsibility to ensure that people are safe and not be victims of violence in whatever form. And in that sense, Bill C-332 seems to me to be useful. There already have been criminal code just provisions for threats, rape, sexual assault. Many of these issues are covered in the criminal code. And so we could delimit this kind of violence. But when we talk about controlling or coercive conduct, or we talk about the control exerted by one person over another, often a spouse with their partner, there are no specific provisions in the criminal code. And I understand the position that you're both defending, and correct me if I'm mistaken, but I think you advocate for training for all of the players in the justice system. But is that not maybe too little? Should we not be more proactive and say, yes, training, but also ensure that the message that we're sending to society is clear? If you act in such a way with your spouse or your partners, and know that it's not training that you're going to get, it's a trial with a sentence in the end. Is it not necessary in the current situation to have such provisions, even though I recognize that 332 needs to be modified a little bit? Do we not have to have clear offenses in that respect? So, Madame Mathieu first, and then Ms. Parsa, could you please answer? Thank you.
Appreciating the thought process, and I think I already said that in my opening statement, that I commend the intent behind it. I think the challenge is that the threshold for a coercive control behavior without satisfying the individual incidents of abuse, which are already as part of the toolbox for the police officers as well as the prosecutors, and those behaviors are already criminalized. So what I am challenged with, and what I am presenting to all of you to think about, is that what this will do is it will create another form of abuse, and then it bears noting for all of us to understand that then this needs to actually be added to as a notion of compounding abuse, right? So the abuse is already happening, and these are the individual incidents, and now we will, on top of it, add the layer of a compounding abuse. So all of those incidents need to be proved. So my question to you is, well, how many incidents are we talking about? How many incidents will make coercive control? What will a survivor will be required to prove? Are we asking survivor to prove that she felt controlled and then that she didn't have a recourse? How will the intent of harm be proved? So I think my challenge is the practical implications, and I feel like as much as it will look really brilliant on the books to have this, it will be really difficult to be utilized in the courts. And we have many other such provisions on our books which were made. Those changes were made for survivors. So criminalizing of the forced marriages, criminalizing of the FGM. There are many other such changes that have been brought forward to protect survivors, but those are never used because they're so difficult for the police officers to understand and for prosecutors to bring forward. And they always go back to the already existing tools and charges that they can already lay. I hope that helps in contextualizing what I'm trying to say. Thank you.
Merci. Madame Parsa, vous avez...
Thank you. Ms. Parsa, do you have anything to add?
Yeah, so I agree with everything that Ms. Mathieu just said. And I just want to point to even the conviction rates that come out of these cases are very low. There was a study that showed in England and Wales, of the 7,000 arrests that were occurring within the time span of the study, only 3% had a conviction rate that was successful. And so even for survivors who are seeking this avenue, the reality is it is not going to result in the result that they're looking for, and it will just lead to further re-traumatization through the trial process and through the court system, especially for something like coercive control, where they will likely be forced to kind of rehash all the experiences of their life and the ways that it impacted them. And
Il reste quelques secondes, Madame Parsa, s'il vous plaît.
There are just a few seconds left, Ms. Parsa. Sorry for interrupting you. Could you tell me just in a few words, how can we explain that some victim protection groups are asking us to adopt 332? How would you explain the difference of opinions between what various witnesses are saying?
I mean, I think that's a difficult question. I certainly understand groups who are advocating in support of this. I think that our experience is based on research and kind of a wider lens of how these laws
Thank you.
have been used to
Thank you
support
very
survivors.
much for that. I will
Merci.
now go to Madame Baron for the last 6 minutes.
Thank you, Chair. I'm happy to be here today covering for my colleague, MP Garrison. And I want to thank the witnesses for bringing further information. There's a lot of important additional context to this discussion that I've heard today. My first question is to Ms. Mathieu. Ms. Mathieu, can you expand a little bit further on, you were discussing the marginalized and racialized people, the additional barriers that are faced, and the lack of trust in the legal system as one example of the barriers that are being faced. I'm wondering, I want to make sure that this is very clear and recorded. Can you expand on that a little bit and provide perhaps a couple of examples further than what you have?
Yes, thank you. In terms of the barriers that racialized and marginalized communities experience, especially the ones who don't speak our official languages and require interpreters and language access in bringing forward their challenges to the legal system, they have a lot of lack of trust on the system because how they are treated in the system routinely. Ms. Parsa just a few minutes back talked about the low conviction rates of a lot of these cases that come forward in the system and the traumatization of the survivors. Traumatization of the survivors who experience inherent bias in the system is even more. They face that whenever they are coming forward, they are not necessarily trusted. They find themselves charged, and that's like one of the historical changes in the criminal code that we are still seeing the repercussions of, and we haven't really found the solution for it. And I just very quickly in closing to this question want to say that I think it is incorrect for us to create a dichotomy between whether this is to support survivor or whether it is not to support survivors. I think the challenge lies somewhere in between, which is that system is not working and the system needs fixing before we go on to bring more charges on the books or more criminal code changes, because on the surface they look really good, but unfortunately they become window dressing. And I have been in front of you and on your colleagues in past many years ago talking the same thing about the forced marriage cases and said that don't criminalize it because it will put the issue under the rugs, and it did put the issue under the rugs. And I don't want coercive control, which has made a lot of progress in our jurisprudence, and the judges are understanding. In the family law context, there are cases where judges are understanding in a much better way. And I don't want that the coercive control again becomes another action that goes under the rugs. People stop talking about it because it's so hard to prove.
Thank you. I think I might move to a different part of my questions that I wanted to ask you based on your response. I did hear Ms. Parsa talking about the conviction rates, and I'm wondering if you can perhaps talk a little bit more around the reporting rates and what you think, just expand a little bit more on how you feel that relates to this bill, and if you feel that we would see an increase of women reporting abuse as a result of a tool being brought forward to be able to do so.
I, from my personal experience, doubt it because I have seen what has happened with the FGM and forced marriages. I don't necessarily believe that there will be increase in the reporting rate, but going by the experience of England and Wales, where there was increase in the reporting rate, I want to highlight that only 6% of the charges brought forward actually saw a prosecution. So it is not necessarily that the reporting rate would mean that there will be more people made accountable. And that unless and until we balance that accountability, I think the purpose and the ethos of the criminal justice system is not met.
Thank you. With the reporting though, and I do recognize there's a low reporting rate, there's a low conviction rate, but would the reporting in itself provide opportunities to look at other supports, so looking at different forms of moving forward with a more, restorative process, looking at, increasing supports, looking at getting the pattern of abuse documented. What are your thoughts on perhaps the benefits of seeing an increase of reporting that may result from this tool?
Unfortunately, I think increase in reporting without really a proper solution offered, and we don't have those mechanisms, right? Like the restorative justice system and transformative justice system, and I also want to highlight that if we come to those solutions, there will be further discussions and further advisory needed and further conversations needed. So because we don't have that in the system in existence right now, hence we have the reservation, right? So I work with the organization which serves 14,000 people who survive violence every year. So I should be the first one saying, yes, please bring on another tool. My challenge is that I provide those services in an environment where the environment is really broken for the most marginalized. People from immigrant communities and non-status communities don't even want to come forward and report the crimes for the fear of the deportation, for the fear of further repercussions. So in that environment, I find it really difficult to support the idea to create another law without the supports available.
Thank you for the additional information. What I'm trying to navigate, because I do agree, there are many, with much of what you're saying, I do agree that there are serious problems in our justice system. I do agree that we need to be looking at this through a systemic lens, that there are serious issues in the supports.
Thank you, Ms. Baron.
I'll end there, but I appreciate your comments. Thank you.
So we have a few minutes left. I'm trying to maneuver our time. So perhaps what I'll do is I'll cut in half. And I'll go to Mr. Van Popta perhaps for 2.5 minutes.
Good. We'll do our best with 2.5 minutes. This question will be for Ms. Parsa. We heard from you and Ms. Matu as well, and other witnesses earlier in the study that Bill C-332 is not the answer, and we recognize that fully is just another tool. We're saying, and we're being told, and we've heard from you as well, that education is more important. Training for police, education for Crown prosecutors, enhanced court worker programs is what we heard from earlier witnesses. But aren't we creating a false dichotomy between law and education? Like, why can't they both be done? Why is one mutually exclusive to the other? And so, Ms. Parsa, I have a great quote from you. In your submission, says, the expressive power of law may also send a message of condemnation of this form of violence to society. I fully agree with that. The law itself can be educational.
I think you're speaking from our written brief, and I think that I do agree with that in certain situations, and I think that is kind of one of the benefits that is being put out as a reason for criminalizing. However, in our brief, as we say, we do not think that these benefits outshine the many, many risks that are being posed by creating a new criminal law. I also think that I understand your question about, why is this a dichotomy? I actually think the question should be, why does training only exist when there is a new law? What we're advocating for is increased training around coercive control within the current system so that police, law enforcement, justice system actors become aware of the complexities of what this abuse looks like. You don't need a law to kind of gain a deeper understanding of intimate partner violence. And in addition to training, I think there should be more public awareness campaigns as well, so that women and survivors are also aware of situations of coercive control and can begin to kind of think about their own experiences through that lens. And so the criminal law, while some may say it has an expressive power, and it certainly can in situations, that doesn't outweigh kind of the many risks that I've written about in that brief as well, and that we've been talking about.
Thank you. I think that's all the time we have.
Thank you very much. Madame Dillon, 2.5 minutes.
Thank you, Madam Chair. I've been very carefully listening to the witnesses. If either one cares to answer, Do you not think that having this kind of mechanism in the law would allow those who are voiceless to step forward if it's their choice to come and report such abuse being perpetrated on them? Does it not at least give them that option, that choice to raise a voice against this? I mean, not having anything at all is more harmful than being able to have a mechanism that allows you to express such insidious abuse. And we've heard other witnesses even talking about how pets are being used in this type of abuse. Do you not think it's important that a person who is going through this be able to come forward if that's their choice and have themselves protected in some way? Thank you.
I can take on Roxana, and I'll pass it on to you if I have time left. I just want to say that I don't think me or Roxana or others who are talking about the systemic challenges currently, which doesn't allow survivors to come forward safely, are talking about that survivors shouldn't have a choice. We work from a trauma-centric, survivor-centric way, and we definitely believe that the survivors should have all the choices and all the options. They should have buffet of options to choose from in terms of what actions they want to take. Unfortunately, honorable member, what I am trying to talk about is that when they make those choices, they are in an environment where there are risks associated with those choices. The studies tell us that number of women who come forward are at much higher risk of lethality as compared to the women who don't interact with the system. So when you have a system which is so broken, which doesn't do risk assessment of their situations properly, which doesn't provide them the support in coming forward, creating another criminal code change and making another criminal law change and bringing forward a crime of course of control can potentially create a window dressing and potentially create more harm and re-traumatize survivors because they will come forward. There will be no action taken. They will be putting themselves at risk with no recourse available to them. And that's where our fear is with this change.
But do they not put themselves at risk in any other law that helps to protect women who are victims of intimate partner violence? Anytime they step forward, there's always a risk. Do you not believe that that is the case? If anyone can quickly answer. Do I have time?
I'm afraid, although I would encourage the witnesses, based on the questions you're receiving, if there's anything that you believe needs to be clarified or further added, to please send the committee something in writing. Maybe what I'll do for fairness, I'll give Monsieur Fortin seulement une minute s'il y a quelque chose.
Mr. Fortin, I'll give you just 1 minute if there's something that you really want to ask. Otherwise, well, in 1 minute. My colleague found it difficult to do it in 2.5 minutes, but I will be satisfied myself by saying that I appreciate the amendments such as that we have in Brooks Place's amendments that are supported by Ms. Barbara Schlifer. It's useful. I am skeptical about the idea of just providing training, but I'm convinced we have to give training and raise the consciousness in the population. So I think it's important to pass through those steps. But I will read your brief very carefully and maybe find good ideas to improve SC 332. Thank you. Thank you, Mr. Fortin.
Spadon.
Be clear to ask a question, right? Okay, thank you. My question, Ms. Parsa, just quickly, if you can clarify, you had said that, I don't remember the exact wording, but basically you had said that there's increased risk of misinterpretation to see abuse when non-existent. Can you please clarify what you meant by that comment and provide an example? That would be helpful for me. Thank you.
Sure. So I think I was speaking kind of related to building off kind of situations of dual charging. And so oftentimes, specifically dealing with racialized populations, the survivor might be seen as the abuser. And in a situation of coercive control where the behaviors are so subtle and really dependent on the relationship, it's very possible that the abuser would actually kind of portray the survivor as being the perpetrator. And so that's kind of what I meant as misinterpreting, and that is embedded within sort of the discriminatory system.
Thank you very much for that. And again, thank you for both witnesses. And I encourage you, if you feel there's anything more you would like to add, to please send us what you need in writing. What we'll do now is start with our second panel. We have one person who's appearing in person, so please advance to the table. We'll have to take a 1 minute because we have one person. I'd have to suspend one person to be tested for sound. Thank you. We have two witnesses with us. Each of the witnesses will have 5 minutes for their introductory comments. I will watch the time carefully as well for the question period. The round will go, we've got another 39 minutes, so we will do our best to get as much information as we can within that time. I will encourage both witnesses, and I think, Mr. Ombudsman, you're aware of this, but the witness on Zoom, who I don't really see at the moment, you'll need to open your camera. Thank you very much. I will encourage you, if there's any further testimony you would like to give us that you don't have a chance to respond to in your introductory remarks or when you are questioned, to please send it to us in writing, because I will have to, unfortunately, watch the time very closely, and we'll end up having to cut people off if the time does not allow it. I will be very kind to raise the 30 seconds mark at 30 seconds. The problem is when people are on video conference, they don't necessarily see that, so I'll have no choice but to interrupt. So let me start off with welcoming both of you, and I will ask Mr. Benjamin Robach, Ombudsman Fédéral des Victimes d'Actes Criminels, to please commence with his introductory remarks for up to 5 minutes.
Merci. Honorable Chairperson and members of the committee, we gather today on the traditional, unceded, unsurrendered territory of the Algonquin Anishinaabe people. In honoring the leadership, strength, and wisdom of Indigenous peoples, we are reminded of the profound importance of respect, autonomy, and protection of the rights and dignity of all people. These principles guide our discussion on coercive control. Intimate partner violence, or IPV, is an epidemic. It transcends geographic, economic, and cultural boundaries, affecting millions of people. The 2018 Canadian Survey of Safety in Public and Private Spaces found that since the age of 15, 6.2 million women and 4.9 million men in Canada have experienced IPV at some point in their life. Section 7 of the Canadian Charter of Rights and Freedoms guarantees the right to life, liberty, and security of the person and the right not to be deprived thereof. Coercive control violates these fundamental rights, permeating experiences of IPV, sexual exploitation, human trafficking, and criminal harassment. It does require intervention. Bill C-332 would criminalize repeat or continuous patterns of coercive control, providing more tools for police to intervene in patterns of abuse. The current incident-based approach to IPV focuses on physical incidents. This can leave police feeling powerless to intervene in some cases where they believe a person is being harmed, or worse, hoping for a future incident of physical violence so they can protect the victim. There are many things we can learn from the criminalization of coercive control in Ireland, Scotland, and England and Wales. The evidentiary burden on survivors can be heavy. Access to electronic devices and communication records is often required to build a case. Training for police, prosecutors, and judges is critical. And risk assessment tools for coercive control can help to identify patterns of behavior. In Canada, recent amendments to the Divorce Act recognize the harmful impacts of coercive and controlling behavior. But proceedings in family court can be messy. Early in 2024, the National Association of Women in the Law sent a letter to the Government of Canada asking to amend the Divorce Act to ban claims of parental alienation in family disputes because of the harmful impact on women. The letter was endorsed by more than 250 feminist organizations. I'm concerned that the criminalization of coercive control could become equally problematic in family court. Even so, domestic homicide reviews in Canada have identified coercive control as a risk factor in several cases of intimate partner homicide with no previous physical violence. And when a survivor leaves an abusive and controlling partner, the criminalization of coercive control may allow them to access provincial compensation programs to help meet their immediate needs. I know the committee has previously studied the topic and heard from our office in addition to experts in the field. I support the criminalization of coercive control, but it must be accompanied by systemic change. I urge the government to respond to the calls of the Mass Casualty Commission by declaring gender-based intimate partner and family violence an epidemic and committing to primary prevention. Some final thoughts. Justice Canada helped develop the HELP toolkit for lawyers after the Divorce Act was amended to include coercive control. It could be updated to reflect changes to the criminal code. Recommend using the definition of intimate partner violence under Section 2 of the criminal code, removing the 2-year time limit after separation, and strengthening victim rights to improve gender equality in the criminal justice system. Thank you for the invitation.
Thank you very much. Welcome to Madame Melanie Omenijo, Women of the Métis Nation. You have up to 5 minutes.
Thank you very much. My name is Melanie Omenijo, and I'm the president of La Femme Chifo Tepimsawak. I'd like to acknowledge that I'm joining you today from Treaty 6 territory in the motherland of the Métis Nation. La Femme Chifo is known as a national Indigenous women's organization who is mandated to represent women of the Métis Nation across the Métis Nation motherland. We advocate nationally and internationally for equal treatment, health, well-being of all Métis people with a focus on rights, needs, and priorities of Métis women, youth, children, and 2S LGBTQIA+ Métis people. I'd like to present that we proceed with caution around Bill C-332, an act to amend the criminal code, controlling coercive conduct. Although we are supportive of it in principle, this bill does not go far enough to fully define the act of coercive control and limits it only in terms of intimate partner relationships. To begin with, this puts the burden of proof of significant fear of violence on victims. Victims of coercive control often don't identify what they are experiencing as coercive control, and as it happens slowly and insidiously without, I apologize, just give me 1 sec. I have a pet that wanted to be involved. Coercive control exists beyond a 2-year limit on domestic relationship and does occur between intimate partners who have not agreed to be married. In this light, we recommend that before passing this bill, we must redefine persons who are connected. What this bill also fails to recognize is the unique presentation of violence in the 2S LGBTQIA+ relationships. Regarding sexual exploitation, this act does not include this controlling and coercive conduct within the existing definition. It also does not include children and other family members who may also fall victims. Canada has used as an example the bill passed in the UK around controlling or coercive control. What the UK bill does not consider is the specific implications around Métis women and the strained historical relationship with police and other colonial processes. Indigenous women living at the intersection of multiple sites of oppression face the highest rates of violence of all, especially Indigenous women with current or past child welfare involvement, who are living in poverty, are often homeless or unhoused, disabled, or navigating trauma and different substance abuse. About 2/3 of Métis women self-report experiencing physical or sexual violence in their lifetimes. Nearly half are survivors of intimate partner violence. This law relies heavily on the myth that police are the only ones who can keep us safe. It would be part of a police officer's role in determining if a situation should be considered as controlling or coercive conduct. Police attitudes especially usually focus on the presence of physical violence and focus on specific incidents rather than a pattern of coercive control. This focus also minimizes other forms of violence. Too often in these cases, police do not see survivors as credible victims or witnesses. Rather than assessing protection, survivors are approached with dismissals and suspicion. We also know that Indigenous women are being criminalized for fighting back. This is reflected in the stats showing Indigenous women are 13 and 15 times more likely to be incarcerated than non-Indigenous women and Indigenous men. Indigenous women's incarceration rates in provincial jails are also alarming. In Saskatchewan, Indigenous women are 29 times more likely to be jailed than non-Indigenous women. What is also integral is the enactment of this bill is a robust plan for information sharing, training, and education. This is not limited to police and all players around the justice system, but most importantly for women and gender diverse folks to understand what controlling or coercive control is. The emphasis of risk assessment tools on physical violence and injuries leads to the minimization of non-physical violence. We ask if police officers will be able to assess intimate partner violence situations that do not present physical violence when they arrive on the scene. Will they have enough understanding of the dynamic to see if there are in a presence of potentially harmful situation where coercive control is an issue?
Thank you, Madame. Two comments. One, they were unable to hear you very well. They're asking when you are responding to questions from members, perhaps you can adjust the mic right to your mouth. And I also noticed you had a script. If there's more that you wanted to send us or you wanted to send the script in, that would be valuable as well, and we can distribute that to the members. So let me now move on to the round of questioning, and we will start with Madame Gladue.
Thank you, Chair, and thank you to the witnesses for being here today. We have learned a lot today. When I first heard about this coercive control law, I thought, yeah, we need a law. And I was hearing that, you know, great things happened in the UK and all these other countries. But then today we heard that out of all of the people that come forward on coercive control, only 6% actually get a prosecution going on. And out of the ones that are prosecuted, out of 700 cases that they looked at, there's only 3% that got a conviction. So that really worries me, because if you think about people who have the courage to come forward on coercive control, and then you think of the justice system and the delays, those people are very much at risk from, an escalation of violence from that intimate partner during that period of time. Now, I'm going to start with Mr. Roebuck. You said that the evidentiary burden on victims is high, and you talked a bit about primary prevention. Can you elaborate on those two things?
So gender-based violence is rooted in gender inequality in society, and so anything that we can do to strengthen gender equality has a preventative impact on gender-based violence. And that was a recommendation as well from the Mass Casualty Commission. When we're looking at violence within relationships, we're already far down the road and looking at responding rather than prevention. And so training in schools on healthy relationships and lots of different things that are being put in place, I think, are important, including the work in the National Action Plan to end gender-based violence. Similar to criminal harassment, it's possible to end up with a law where survivors have to pull together and document and feel the pressure of creating a timeline and gathering all of this content themselves and trying to curate years worth of controlling behaviors. And if the burden is on the survivor to demonstrate that fear and that concern, then I think that creates an unfair burden. So I do prefer a model that shifts that onus onto the perpetrator. But yeah, I think within the criminal justice system as well, one of the challenges that we have is that in gender-based violence, we predominantly male offenders whose rights are guaranteed under the Charter and they're very clear, but victims' rights aren't enforceable, and there's lots of gaps that could be improved. And so when people come into contact with the system, it can be really messy. Yeah.
Very good, thank you. And now for Ms. Omeneho. First of all, I want to say my daughters and my grandchildren are status Métis, so I want to thank you for your advocacy on the behalf of Métis women. One of the things that often happens in Parliament is we put things forward and we don't see them through the lens of Indigenous people, and we think that these solutions will fit. Can you give us some advice about what needs to happen to this bill in order for it to be more connected to Métis culture and what Métis women experience?
Yes, I can actually. So there is, first off, I want to put in that the other thing that hasn't been really considered is that many of our very young women who are often seen as children within the government process are not protected with this bill. And I think that it's really important that we find something that includes them. But I also believe that there are things that need to be put in place to ensure that the issues that relate to Indigenous women and the lives of where they come from and some of the issues of oppression that they deal with will be addressed with this law, so that police don't see it, because very often, even for things like I can tell you with Gladue reports that are supposed to be benefit us, and in fact it was a Métis woman that a situation with the justice system that resulted in a Gladue, they do not get the opportunity to present Gladue at court and stuff. They are eliminated because it doesn't specifically address the Métis. And so we need to make sure that when we're doing these laws, that distinction-based processes doesn't eliminate any Indigenous people from having access and protection. And police can be somewhat subjective. And I'd love to tell you that there isn't racism within our existing systems, but racism is alive and well in this country. And many of our Métis women come face to face with that within the justice system and with police services. So I believe that this law needs to have those things in place to help protect Indigenous women rather than make them another victim of something else that happens within the justice system.
Very good. And I agree with what your comments are. And we saw the same thing when we talked about sexual assault and, the difficulty, the underreporting, the lack of follow-up, the trauma in the justice system, and then at the end of the day, very low conviction rates. And so training was recommended for judges and officers and whatnot in that light. And coercive control is even more difficult to define. And so one thing I'd like for you to do is to send us the definition improvement of people in a relation. I was interested in that, and I'm out of time. Thank you so much.
Thank you very much. Madame Brière, s'il vous plaît.
Merci, Madame la Présidente.
Thank you, Madam Chair.
This morning, I'll ask my questions in French. Vous avez tous les...
Both of you broached the issue of definitions of coercive control. And Ms. Omenio, you've said that the bill doesn't go far enough to define what coercive control is. So I would like to hear both of you speak on this. Would it be necessary to add a definition? And what can we do to recognize or to prove coercive control?
Did you want me to start?
Oh, go ahead, Melanie.
It's up to, sorry. I want to tell you that we need to define coercive control, because when you're relying on, which you are with this bill, on police to be able to define that and the justice system, if there isn't clear defined parameters about what coercive control is, not only will our community not be able to see themselves if they're under or if coercive control is a part of what they're experiencing, but the police will, rather than help support them in pushing forward to put perpetrators into a position of being charged, they'll say, well, they don't have enough parameters, we're not sure if this meets. So because of that subjective nature, it has to be defined as to what is coercive control, and maybe even examples of coercive control.
Thank you, Chairperson. I think that there can be a combination of the definition in the law and then practice guidelines. In the UK, they have a guide that provides comprehensive instructions on how to interpret and apply coercive control legislation, and those examples, I think, are helpful. I believe the committee also met with Dr. Carmen Gill, and I've been able to see some of the work that she's been doing on research to train police and to help them recognize signs and symptoms of coercive control. So I think that would be a necessary component, whether it's captured in the law itself or in very clear guidelines, but there should be clear guidance on how to recognize and intervene.
Merci, thank you very much. Peut-être étiez-vous présent?
Maybe you were present during the first hour when we heard our two preceding witnesses. We were told that this could represent an increased risk that the police services see abuse when there isn't any. So, Ms. Omenio, I'd like to hear what you have to say about this, about the undesirable consequences or unintentional consequences, especially with racialized populations.
When it comes to intimate partner violence, very often police may misinterpret, but I want to tell you our experience has been with the women that we've worked with and who have told us their stories, is that very often the police officers don't take their intimate partner violence seriously, and they actually are left to be victims. And in fact, we can show you story after story where police didn't properly approach situations in a careful way, and women ended up dead. So it isn't always a clear case. And I know that intimate partner violence is a very tough thing, because it means usually people that are trying to be controlling and trying to be coercive and with their partners do not let the outward world, including police services, see what's happening. So I'm going to be I'm probably going to be the person that tells you that I think that there will be far more police looking and not seeing the coercive control than there is going to be that they've overstepped and are charging people that wouldn't be found. And I agree with what the previous speaker had said too, that the justice system is set up to protect the people that are being accused. It's not there for the victims. So I think that there's many places within the justice system that would help support them if they were wrongfully accused.
Thank you again. Vous avez aussi mentionné.
You also mentioned that the fact of criminalizing coercive control might minimize the presence of other offenses. Could you tell us more about that?
Il vous reste seulement 30 secondes. Je ne sais pas si...
He was asking you to answer that, but if you haven't...
Madame Omenio, est-ce que vous avez...
Ms. Omenio, did you hear the question?
Apologize. So I didn't really, I was trying to get it, but I didn't.
Okay.
Je m'excuse, mais
Okay.
I think...
Okay, I'm sorry.
Vous pouvez...
Non, mais je pourrais le faire, mais je pense, Madame la Présidente...
I could do it, but Madam Chair, I think I would like a call to order, not because I'm liberal, but I think that when a question is asked in French and the witness doesn't hear it, the 30 seconds that was remaining should be given to the witness again, and I'm doing it in a nonpartisan way, but I think just to respect bilingualism, we should allow a reasonable period of time for everyone to ask questions and hear the answers. No problem with me if you want to take 30 seconds. Thank you. So, Ms. Omenio, my question was, you mentioned that criminalizing coercive control might minimize the presence of other offenses.
That is sometimes the physical violence as well as the emotional and financial violences that women often are victims of may not be as seen if they just focus on coercive control. So it is important that when they're doing these things that they don't leave out the other parts of where intimate partner violence can really be harmful to the people in our community.
Thank you very much. And that was 55 seconds, but it was only fair to hear the response. Monsieur Fortin.
Thank you, Madam Chair. Thank you to the witnesses who are here with us today. My question is for Mr. Roebuck. You're the federal ombudsman for victims of criminal acts. So you must hear people speaking to you every day who talk to you about the virtues and the defects of our criminal system. We heard people tell us this morning say that C-332 is a bit dangerous because there's the issue of doubling complaints, and also we're afraid that victims will be portrayed as aggressors excessively because they want to protect their children. Is there a problem with that? The idea of the definitions or the way in which our bill was structured so that victims might be penalized. And secondly, I heard you say in the beginning that you made some recommendations that I found very interesting. I see that you are proposing that we refer to Section 2 of the Criminal Code for definitions and that we remove the 2-year limit. We've already heard that, but I would like it if it's possible for you. I didn't see your brief. I don't know if there's a brief that was prepared that we didn't receive or if I'm the only one who didn't get it, but I would like to have either a copy of your introductory notes or of your brief. But I'll come back to the preceding question I had on the problem that victims might be considered as people having coercive conduct when they're defending themselves.
A lot in our office about coercive control challenges with family court. I have more concern, to be honest, about how these issues play out in family court than how they're likely to play out in the criminal court. And the interplay between the criminal justice system and family court affects people in real time in custody decisions with their children. And so I think it's a challenging space to find the right balance of the protections for somebody who's been accused and the rights of and the needs of the person who's been harmed. So I do think that there's a risk for this to be abused, to have allegations of coercive control flippantly provided in family court. I think that that happens in family court already, but if it's a criminalized offense, then that creates a complicated follow-up, I suppose.
Pourriez-vous donner des exemples de situations où ça pourrait...
Could you give us examples of situations where this could be a problem or would be a problem?
As a researcher on youth homelessness, before coming into the role, there were a lot of young people who would become homeless as a result of high conflict in their home. And so maybe there's a high conflict divorce that's happening, or a blended family where the young person is targeted because of the relationship to their parent who's experiencing abuse. I think that the line where there's reciprocal violence becomes difficult. It's hard to differentiate when is somebody fighting back or when is somebody fighting. And that's the nuance that's really challenging to apply the law to partner violence in general.
Okay. Et est-ce que...
And, in your opinion, would it would be sufficient to amend C-32? There are the two amendments you suggested. That's why I want to just, maybe you have others. What would you recommend in addition to improve C-332 to better protect victims and punish people who have a tendency to have this kind of behavior?
Victim rights to carry the same weight as the rights of the accused, and in particular that a victim should have the right to be informed of what their rights are when they report an offense. In particular, in cases of partner violence, there's independent legal advice that's available, but we hear in our office often from people who say they were never informed. They didn't know that they could speak to a lawyer for free for advice on the system. And so I think those are pieces that have to come into place if we want to tackle these challenging issues.
OK. On dit au projet de loi qu'il faut avoir...
In the bill, the offense is to have controlling or coercive conduct in a continuous or a repetitive manner. And this repetition factor, is that a good thing, or should that be amended? I'd like to know what you have to say about it.
Recognition of patterns of behavior, because one of the challenges with policing and intervening in situations is they might see something that they perceive as relatively minor, and the implications of the control involved aren't obvious to them. And so being able to see, oh, actually, every Friday night, you're not allowed to leave the home, versus seeing it just once. I think patterns are really important, so that's a strength of this law.
15 secondes. 10 secondes.
Merci, Monsieur Roebuck.
Thank you, Mr. Roebuck.
For the final 6-minute round, Madame Baron, s'il vous plaît.
Thank you, Chair. And thank you to our witnesses. There's just so many questions to ask that it's almost overwhelming to figure out what are the most important ones, in particular, since I don't have the opportunity to attend this committee as often as I would like, in particular talking about this study. And so one thing that I've been reflecting on is the bigger discussion here around the fact that we're talking about a tool a tool to be able to move forward in a positive direction, but in no way is this going to resolve the complexity of the systemic issues of the interconnection of there's just so many pieces that need to be looked at. But I do appreciate that we're looking at moving forward with this specific tool, but I also like that we're talking about the bigger pieces here. And so one thing that I'm thinking about is the fact that we're talking about training RCMP, training judges, and that's very, very important and absolutely a big piece of this. But also I'm reflecting on the fact that we should be providing through this study recommendations on how we can revamp the systems that we're currently in. So for example, in my community of Nanaimo Ladysmith, they have implemented a system now where there is a community, or if there's an RCMP officer who arrives on the scene with a mental health nurse. So looking at increasing the and supplementing the existing RCMP system with mental health support workers or with those who would be more readily trained and have the expertise to be able to identify the problem at hand. And so I'm wondering, Mr. Roebuck, if you can please share your thoughts on some of the ways that we can complement, we need to revamp the system and what your thoughts are on that as just one example of how to best move forward.
Thank you. I think you're touching on a nerve for people in the anti-violence sector who have so much expertise, and if we compensated them the same way as we compensated police to arrive on scene to respond to cases of partner violence, then we might have different outcomes. So I think, exploring partnerships that bring together the safety that comes with, for some people, I suppose, with the availability of a police intervention if there's violence is important. But I do think that the expertise of anti-violence workers needs to be central to this conversation and looking to involve them.
Yeah. That's great. Thank you, because I agree we need to increase training and awareness, but it is complex, and we do have people who have ample years of education, experience on the ground, and they're not being fully utilized. In particular, when we talk about Indigenous people and racialized and marginalized communities, there's it's important that we are including those voices. And I'm wondering, Ms. Omoniho, if you can provide any additional thoughts that you have on this as well.
So I do agree with you. Indigenous women are treated differently within these various institutions and systems that were set up to protect most people. They feel very vulnerable and they don't feel protected. I do think this is a tool that can be used, but I just want to even clarify for this committee. Yes, there is a gender-based violence plan that was under Women and Gender Equality. That plan might be as great as all the words that are written. I know we were a part of developing some of those plans, but truthfully, the wage funding for gender-based violence, $536 million, was divided up 13 ways and given in a transfer payment to all the provinces and territories. Gender-based violence wasn't put forward as a priority to help do programming and to help fix the justice system to change how things are.
Thank you. And perhaps I'll continue on another question to you. You were talking about, through the chair, the importance of victims being able to identify that they are experiencing coercive control. And I'm wondering if you can share a little bit more around that and your thoughts around the importance of education, healthcare, if people are not aware of the patterns of coercive control, if it's normalized, the violence and coercive control patterns, how can we possibly expect victims to self-identify as experiencing it? So I'm wondering if you can share your thoughts on that.
So many of the women in our community don't even understand what their rights are or how to protect themselves. And very often they're in these very unhealthy, codependent type relationships that they start protecting the perpetrator rather than protecting themselves. And sometimes it means the loss of their children to child welfare systems. It's an ongoing cycle when they're in the throes of these. So it's really important for them, even at young years, let's start teaching our young people what things like gender-based violence and coercive control really are.
That's great. I only have probably 25 seconds left, and so with that, I'll just say thank you so much to both of you for all your work, and I would love to hear a little bit more as well, perhaps in a written submission around the interconnection between poverty and how it relates to this bill and addressing the issues of affordable housing, of access to the incomes required so that the patterns of coercive control are not as accessible and available.
Thank you very much. I'll move to a final round, and I'll abbreviate the timing to 2.5 minutes to Mr. Van Popta, followed by Mr. Housefather for 2.5 minutes.
Thank you. Mr. Roebuck, question for you. Bill C-332 proposes that the relevant controlling and coercive conduct must be proven to have had a significant impact on the victim. Now, earlier witnesses, last week or 2 weeks ago in the study, expressed some concern that this could re-victimize the victim, in that the victim would have to give it evidence as to her, usually a woman, her state of mind on the witness stand and be subject to cross-examination on that. And we were also pointed to Scotland's Domestic Abuse Act, which puts a focus on the intentions and actions of the perpetrator. Quote, a reasonable person would consider the course of behavior to be likely to cause the victim to suffer physical or psychological harm. So what do you say about that? Is that a better way to go to prevent and avoid victims being re-victimized, which is of course, your profession?
I think it has pros and cons. I think it's better to have an objective person test like what they have in Scotland rather than trying to get someone to justify that their trauma is significant enough that it merits intervention. I think on the criminalization side, then it also increases the risk of somebody from the outside looking at behaviors and saying, well, that seems to be problematic without really understanding the full context of what might be happening in that relationship.
We also heard from earlier witnesses that Bill C-332 might have the inadvertent effect of criminalizing communities that are already over-criminalized. I was somewhat concerned about that. But I was reading something written by your predecessor, Miss Heidi Illingsworth. She had given testimony on a similar study. And she said, quote, this intimate partner violence is a pan-Canadian issue, as this type of violence knows no boundaries. IPV affects people of all genders, ages, socioeconomic, racial, educational, ethnic, religious, and cultural backgrounds. And she cites a study from Statistics Canada from 2019. I would think that that's probably a pretty good source of evidence. So your comments on that.
Would we be able to receive those comments in writing? Thank you very much. For the final 2.5 minutes for Mr. Housefather, please.
Thank you, Madam Chair, and I want to thank the witness. I'm actually going to talk about something else. On December the 11th, I put forward a notice of motion related to a really important study, and I know we don't have time to deal with this in my 2.5 minutes. I just want to go on the record putting this out that I am going to be moving at the next meeting of the committee when we come back in 2 weeks, that pursuant to Standing Order 1082 and in view of the alarming escalation of anti-Semitism in Canada, the committee undertake a study on the issue of anti-Semitism and the additional measures that could be taken to address the valid fears that are being expressed by Canada's Jewish community, that the study include but not be limited to the issue of anti-Semitism on university campuses, that the study should be at least 3 meetings, and that the committee report its findings to the House. I know the subcommittee will be discussing this afterwards, but I know a lot of my colleagues sympathize and agree that this is an important study that we should be doing. This has not gone away since October the 7th. There's been a dramatic escalation in anti-Semitic incidents all across the country in Canada's big cities. And that's not to say that there have not been an increase in other incidents for other communities, such as the Muslim community, and I would welcome other studies on that issue as well. But the numbers on anti-Semitism, Jews constitute 1.1% of Canada's population. Over 70% of incidents, religious-based incidents, are anti-Jewish. And students at campuses across the country have come to me. I have spoken at Hillels across the country. Yesterday at UBC, there was a referendum proposal to end the lease with Hillel. there are just constant incidents across the country that we as a committee, I think, have to do the diligence to look at what we as a national government and what moral suasion we can give to university administrations, municipal governments, provincial governments to act. So appreciate that with my colleagues and look forward to the subcommittee discussing it, and I do intend to move that when we come back. Thank you, Madam Chair.
Thank you, Mr. Housefather. And with that final word, I'm going to thank the witnesses that appeared before us. If you insist, I can give you 1 minute.
I'd like to.
Please go.
Merci.
Absolument.
Merci, Madame la
60
Présidente.
secondes.
Monsieur.
Thank you, Madam Chair. Mr. Roebuck, I have 1 minute, so quickly. I heard you answer my colleague's question on appreciation. So a subjective or objective appreciation or evaluation. The victims wanted an objective evaluation of the system without having to testify. But you're saying, no, we have to see the effect it had on the victim and take the context into account. Could you explain that further?
The victim feels, but I don't think that there should be a burden of proof on them to establish that their trauma is significant enough to merit intervention.
Merci.
Merci beaucoup. Est-ce que vous voulez...
Thank you very much. Would you also like 60 seconds?
Thank you. A very a quick question, actually, to Ms. Almonijo. You had spoken about 2/3 of Métis women self-report, and I believe you had said intimate partner violence. Maybe you can clarify that, and any further thoughts that you have based on that statistic that you put forward.
Those are statistics that we have from Stats Canada and other reports that have been done. And it is 65% of Métis women have experienced intimate partner violence. But I also want to tell you that I think that a lot of this bill and what isn't being talked about in this committee is how the 2S LGBTQIA community is also affected by gender-based violence and the issues that relate to coercive control.
Thank you very much to both our witnesses. We will suspend for a minute or two to allow all our witnesses on Zoom, but also in the room, to leave because we will return back in camera to discuss committee business.